Hello everyone, welcome to Clashilla. This is Avinash Sabha, your educator, and I have come up with a fresh topic today, so let's get there. The Supreme Court acknowledges the need to provide the accused in death penalty cases a meaningful, real, and effective hearing on mitigating circumstances. Comment. The issue of how to give offenders facing the death penalty a meaningful, genuine, and effective hearing of their mitigating circumstances before a trial judge has been sent by the Supreme Court to a constitutional bench. The presentation of mitigating circumstances by an accused person to avert the extreme sentence of death was deemed a valuable privilege by a three-judge bench chaired by the former Chief Justice of India, UU Lalit. The trial judge sentenced to an accused person to death following a formal, if not merely formal, punishment hearing. The hearing may take place on the same day as per the conviction order in specific circumstances. The decision by the Supreme Court to send the issue of a fair opportunity to a constitutional bench recognizes and attempts to settle the age-old argument about whether the trial courts are arbitrarily using the death penalty, even though it's regarded as the rarest of all punishments. The ruling is a significant step towards humanizing the sentencing procedure, as current thought tends to emphasize the importance of the socio-economic status and mental state of the accused or convict when determining the appropriate sentence. According to the Supreme Court, the accused has a right to a fair trial before the conviction. The goal of punishment is to create the prospect of reform and not retaliation. Death sentences are increasing even though they are only used in the rarest of rare cases. As opposed to the death penalty, the Supreme Court believes the court should examine mitigating elements before imposing life imprisonment. These mitigating circumstances should be taken into account before the trial and not after the conviction. The facts and circumstances of the offense or the case, as well as the circumstances of the offender, must be considered as it has some serious effects on our society. India, with its huge population and diverse culture, needs strict laws to prevent crimes. To discourage criminals, the aggravating offender must get a death sentence. To promote morality and promote the victim's sense of tranquility, the death penalty should be applied in the rarest of rare cases, such as those involving in terrorism as well as rape. The antisocial elements must be eliminated swiftly and thoroughly to preserve societal peace. The tranquility of the victim's community would be disrupted, and the victim's life will be at risk if the death penalty is abolished and life imprisonment is designated as the death sentence. Additionally, it has some detrimental effects on society. As we can see, rapes and murders are on the rise, even in the wake of the Delhi gang rape. Therefore, it is in no way demonstrated that the death sentence deters criminal activity. It even violates the Article 21, that is the right to life of the Indian Constitution. The rarest of rare doctrine, which was created by the Supreme Court, states that no criminal with aggravating circumstances should be given a free pass in the court. Instead, they should be given the chance to have a fair hearing as well as to defend themselves.